Welcome to the HIPAA Compliance for Group Health Plans webinar, as my colleagues and I hope to help plan sponsors understand the rules and regulations and obligations associated with their group health plan. Now, please note, today's webinar is not meant to be a HIPAA certification training. Our goal is simply to explain the rules and regulations so that each plan sponsor can set up their own appropriate policies and procedures. Today, I am joined by my colleagues Dennis Fisher and Shelly Hodges Conus. Thank you both so much for joining us today. Now, in an effort to break down the rules, regulations, and even those obligations in a more practical way, we will review the HIPAA foundational principles, the HIPAA privacy and security standards, and end with the HIPAA High-Tech Act. Dennis, would you like to kick us off by discussing the HIPAA foundational principles for us?
Yeah, thank you very much, Don. Before we even tackle that, I think on the first slide it's important to look at some of the penalties. We advance. This is a very interesting chart because it really gives us an idea about the attention to enforcement that's going on these days. For HIPAA violations, you see that they're divided into four important categories. You didn't know, it was just something that fell through the cracks that caused a failure. Reasonable cause might be someone left a laptop in their car and it got stolen, and there's a PHI issue that way. Then below that, you have two categories of willful neglect. One in which you ignore your responsibilities, and the one where if you can correct it within 30 days, you should be able to mitigate the penalties that the regulators would otherwise have to assess against you. Don and Shelley, I think both are going to have some specific examples to show you just how damaging these penalties can be. But again, that goes to this whole area of renewed scrutiny on the HIPAA rules. The last thing here is on the maximum penalties. You see that in all the categories, they really hit $2 million. So it's interesting to note that that number has jumped several $100,000 just in the last 5 or 6 years. So when we look at what is HIPAA, I'll give you a little bit of the history. If you think back to the 1990s and the Clinton administration and their first attempt at healthcare reform, which really petered out, Congress got together and they enacted HIPAA. And although HIPAA is primarily, I think, best known for these privacy and security rules, it did some other interesting things. It had rules about non-discrimination based on health factors, and it was the first effort to mitigate and retire the idea of the pre-existing conditions, because that's what gave us the 63-day break in coverage and those creditable coverage rules. The Department of Health and Human Services is primarily responsible for enforcement of these rules. And in contrast to employer plans that have historically been regulated by the IRS and the DOL especially, those are agencies that I think have a history of more familiarity with how employer plans work. A lot of folks in the industry, I think they attribute some of the bumpiness and some of the difficulty of these HIPAA rules to the fact that HHS hasn't focused on employer plans the way the other agencies have. As we advance, I think we'll look at exactly what HIPAA is intended to do. What it does not intend to do is to chill the movement of health information where it's appropriate and where the safeguards in place. It's not intended to do that in any way. What you do have, though, are some bedrock rules that have been established and an identification of the kinds of areas where this information is potentially exposed. You have verbal discussions. If you're in the doctor's office, there's supposed to be white sound and other things that protect one person from hearing another person, but that doesn't always happen. Written communications, anything that may have been left on a desk, And then what we're most familiar with are the computer communications and the emails, for example, and why we are obliged to send things in an encrypted manner. Uh, the HIPAA rules are really designed to focus on the uses of health information and make sure that those are appropriate, and then also disclosures, where disclosures go to third parties and the problems it creates there. Important rules also about privacy rights. This is almost a constitutional about what person's protections are concerning their health information, their right to authorize it where they see it's appropriate, uh, the right to receive it and to use it. Uh, so that's another important element. And then security standards. How is the covered entity, how is the employer physically protecting the information or electronically protecting it so that they can achieve the obligations that they hold for this um, when they're meeting their HIPAA requirements. So what type of HIPAA information are we looking at here? If we consider it as in subsets, you start with this ocean of everything that is health information. And then the subset within that is the health information that can be linked to a particular individual. So when you marry those two concepts together, you have the HI and the III, you have PHI. And so PHI is really the focus of everything that we're looking at in the HIPAA rules, and it all functions to create a cocoon and make sure that this particular uh, zone of information is really being protected. I also mentioned here at the very bottom, it's kind of an interesting point. Health information maintained as part of the employment record is exempted. So, in an example like FMLA, there are employment law rules that apply to FMLA that protect it. And one of my favorite examples, real life example from a few years ago, is where a client called Hub and she was the HR leader, and she said she was being pressured by her president of the company because there was a guy that was taking FMLA every Friday. He asked for it on an intermittent basis. He said he was getting back treatments. The president was suspicious, and so the president went to her and said, I want to see the health plan records to show what kind of claims Joe was sending about his Friday visits. And this was specifically intended by the law to prohibit that kind of release. As I mentioned, FMLA has its own verification processes and it's all separate from this HIPAA zone that is treated very differently. Now, here we're looking at a variety of elements that are identified in the rules about what makes something identifiable. What is it that you can use? There's a mix here: last name, uh, your biometric information, social security number. Certainly, that's obvious. You connect the dots with that, and you can figure out exactly who owns the information that we're talking about. Also, it's interesting they have some lesser, more subtle elements like a VIN number. I would never think of that in terms of like identifying someone. These are all what the HHS considers the dots that are available to be connected. And so that's what you have to really consider and watch for. So who complies? It's covered entities. So the law is built on who these entities are, and we have it listed here in three columns. The first one, pretty obvious, healthcare providers, because that's doctors, that's hospitals, that's dentists. For health plans in the second column, that's what touches us as Hub employees, because employer group health plans are on that list, along with health insurance companies and some of the government programs, Medicare and so forth. Now, on the far side, you have healthcare clearinghouses. Really, that is considering billing services and coding companies and claims processors. So Those are the three primary areas. And I'll tell you that there's a lot of overlap here too. I think we should point that out, that we have at Hub dozens of medical practices and hospitals that we support. And really, they have two layers of responsibilities because as a hospital, they have requirements that apply to them as a provider of services and the need to protect PHI that arises that way. And then they have a secondary responsibility to apply the rules that connect to the group health plan. Because as employees who are participating, there's this secondary level of protections that they are entitled to receive too. So this is another place that really reaches out and touches us as Hub employees because it's a responsibility that any business associate, and you'll see some listed here, TPAs, brokers like us, consultants, uh, claims processing, these all become business associates because they are handling and using that PHI in support of what belongs to the covered entity. So if you're familiar with something like a business associate agreement, that is really a contractual statement that the associate agrees to utilize the PHI that they're collecting from the covered entity and applying the full range of HIPAA protections that the covered entity owes and applying it to uh, their function as an associate. What jumps out on here, I think, is the range of these programs because uh, you'll see it's pretty broad. You have medical plans, prescription plans, dental. Those may seem obvious too, but wellness programs. Some of the flavors of the wellness programs will also generate this kind of protected information. So we have to be mindful of that. EAPs is another area. There's a lot of attention to EAPs now. So another area that will fall under the umbrella of HIPAA protections. Section 125 cafeteria plans uh, or fall into that same boat. But there is a category of groups that are not, and we'll look at that next here. Yes, exempt plans. At the top, there's a really seldom used exception that's built into HIPAA. If you have 50 or fewer than 50 participants, and you're self-funded, and you're self-administered, then you technically wouldn't apply. The HIPAA rules would not reach you. But the fact is that we have so few clients at that small size that are ever self-funded that we really don't see this. And even if they were, normally you would have a program like that that is being supported by a third party for administration. So that would take them out of this exempt category. Now, below that are some of the programs that are very likely to touch health information. And so you may reflexively think that HIPAA would apply, but they've been carved out. So things like workers' comp, the life insurance, disability, and then as I mentioned earlier about FMLA, uh, those places of those programs generate important information that should be treated in a sensitive manner, but they are really outside of the zone of what we see with HIPAA. Yeah, at this point, thank you. We're going to turn things over to my colleague Shelly. Shelly,
Thank you,
before I,
Dennis. Thank you for laying such a good foundation of the HIPAA rules. Now let's talk about and turn our focus to the privacy and security standards contained in the HIPAA rules. When a plan is fully insured, the majority of responsibility for compliance with the privacy and security standards fall on the insurance carrier as long as the plan sponsor takes what is known as a hands-off approach to protected health information, meaning that they receive a very limited PHI for very specific purposes for use in certain circumstances. We'll take a look at those in a little bit. However, when a plan is self-funded or fully insured and takes what's called a hands-on approach to PHI, meaning that they receive full PHI, the responsibility for compliance with the privacy and security rules falls to the plan, which ultimately means the plan sponsor on behalf of the plan. The privacy rule governs who has access to PHI, how it can be used, and under what circumstances. Additionally, it gives individuals certain rights related to their own PHI. And there are administrative requirements that covered entities must adhere to in the protection of PHI. The security rule provides for the protection of not all PHI, but just that PHI that is electronic. And because the security rule only applies to electronic protected health information, the privacy and security rule work hand in hand to protect PHI from inappropriate access, use, or disclosure in any form. Next slide, please. Now we'll take a look at the components of a privacy program. And this is really what covered entity group health plans are required to do. These are the steps that they have to take in order to develop a robust privacy program and protect PHI. They need to have a set of governing policies and procedures that are intended as a way for guiding the way of appointing a privacy officer, but developing those policies and procedures or standards that individuals adhere to in protecting individually identifiable health information or PHI, in making decisions related to individuals' privacy rights and creating consistency and accountability on the part of the group health plan. They must have a notice of privacy practices that informs individual participants about their rights and how PHI will be used. They must maintain business associate agreements with contractors that apply both privacy and security standards to any entity that has access to the covered entity or plan's PHI on its behalf. They need to have a training program to train associates on their responsibility related to protected health information in the hands of the covered entity. They need to have a process for investigating security incidents, for reviewing those incidences and making determinations of whether they rise to the standard of a breach, of maintaining authorization for those component for the disclosure of protected health information, and audit procedures to make sure that they're adhering to those standards. The HIPAA requirement to maintain privacy and security policies and procedures is separate and distinct from the requirement to distribute a notice of privacy practices. Sometimes these two requirements are often confused by covered entities or plan sponsors with group health plans whose maybe familiarity with HIPAA is a little bit less than a healthcare provider. The plan's privacy policies set the standards for communicating how protected health information is protected, used, and disclosed, a participant's rights under the plan, sanctions in the event of a violation, and documenting compliance with the rules. Conversely, the Notice of Privacy Practices is simply intended to convey the uses and disclosures of PHI that may be made by the covered entity group health plan, the individual's rights to their protected health information, and the covered entity's legal duties with respect to protected health information. The Notice of Privacy Practices must be given to individuals when they enroll in the group health plan upon request, and covered entities must send a reminder of the availability of the Notice of Privacy Practices to participants at least once every 3 years with information on how to obtain a copy of the Notice of Privacy Practices. I think one of the most important things that plan sponsors need to understand when they sponsor self-funded group health plans is that just because they sponsor a group health plan doesn't mean that they have unfettered or unrestricted access to protected health information. It's important to know that a group health plan or plan sponsor on behalf of its group health plan wears two hats. It wears a hat as the plan sponsor, and that it has to act on behalf of its group health plan, and then it wears a hat as employer. And what the permissions that a plan has as the plan are different than the permissions that a covered entity has as the permissions are different for the employer. Employers are not directly subject to the HIPAA rules, but they have to take responsibility for compliance with the HIPAA rules on behalf of the self-funded plans that they sponsor. This is largely the case for fully self-funded plans, but it also includes, sometimes to the surprise of employers, level funded plans, health reimbursement arrangements, and health flexible spending accounts. However, when a plan is fully insured, again, the majority of responsibility falls to the insurance carrier if that plan sponsor is hands-off of PHI. If that plan sponsor is hands-on, they have the same responsibilities to protect PHI as a self-funded plan sponsor. I think it's important, again, to talk about one of the main distinctions of the HIPAA rules, and one of its main foundational purposes is to draw a line between the employer and the group health plan for protection of plan participants. With the employer's dual role and those dual responsibilities in mind, again, disclosures of PHI from the group health plan to the employer can only be made if the employer, as plan sponsor, has taken steps to comply with the HIPAA rules and provided assurances to the plan that it has amended plan documents to inform participants of the circumstances in which it can make a disclosure of protected health information, and it gives guarantees to the plan that it will not use PHI for employment purposes, that it will only use PHI for the administration of the plan, that it will assist individuals with the amendment, access, and accounting of their individual PHI, and that there will be adequate separation between the plan and plan sponsor in place. Next slide. In absence of privacy and security policies and procedures, there are some permissible ways that the plan can share protected health information with the employer as the plan sponsor. They can share limited information for the purpose of enrollment and disenrollment in the plan. So for their adding participants to coverage or taking participants off of coverage. They may have access to de-identified information. De-identified information is protected health information where all 18 factors, which are considered to make something individually identifiable, have been removed, or there has been actuarial certification that that information can't reasonably be used to identify an individual participant. Once information is de-identified, it can be used for any purpose. The plan can make disclosures to the employer if there's a relevant authorization in place from the participant giving permission to the plan to share that information with employer. And employers can receive summary health information for the purpose of bidding insurance or making plan design changes. Summary health information is a subset of protected health information in which all individually identifiable information has been removed from the relevant files with the exception of 5-digit zip code. Next slide, please. If a plan sponsor has full HIPAA privacy and security policies and procedures in place, they do not need authorization to disclose protected health information for treatment, payment, or healthcare operations. The majority of a self-funded plan sponsor's permitted uses of PHI without authorization will be related to healthcare operations of the plan or payment. As plan sponsors, employers are not as involved in the provision of health care, so generally it's not going to be a treatment-related disclosure. Examples of permitted disclosures include eligibility determination, billing, and evaluation of health plan performance for the purpose of plan design changes or renewing coverage. However, other PHI disclosures not related to treatment, payment, and healthcare operations do require authorization of the individual. Next slide, please. Individual authorization is required for the use of PHI in what we call non-routine disclosures. Those non-routine disclosures include anything other than treatment, payment, or healthcare operations. So those type of events could include court order or subpoena, disclosure to a workers' compensation plan, a disclosure to law enforcement, or for public health purposes. Those are just some examples. But in general, when it comes to obtaining authorization to disclose an individual's protected health information by the employer or by the plan, they can't condition a participant's enrollment or eligibility for benefits on providing that authorization. However, conditional authorization can be required prior to an individual's enrollment in the plan for purposes of eligibility, underwriting, or rating determinations. So in general, a participant has to freely give authorization to release their PHI for any reason other than treatment, payment, or healthcare operations. Now, it's very common for employers to assist employees with claim adjudication. But is authorization required when they do? And that answer is really maybe. Employers can generally assist an employee who gives information to the employer because they've given it freely, they've given their consent and authorization. If the employee is right there, the employee can also give that authorization to the insurance carrier right then and there on the spot to help them with their claim issue. That is true regardless of how a plan is funded. But if an employer who is required to has full HIPAA privacy and security policies and procedures, if the plan is self-funded or the fully insured plan is hands-on for PHI, creating the required separation between the plan and the employer, and that employer is acting in its capacity as a representative of the plan, they may disclose PHI and help the employee with their claim issue without authorization. Otherwise, though, again, those employers without privacy and security policies and procedures in place must obtain authorization to provide assistance to employees if the employee is not right there with them. Now, disclosures of protected health information should also adhere to what is called the minimum necessary standard. This means that sharing protected health information should be limited to the least amount of information necessary to achieve the intended purpose of the disclosure. While releases of PHI pursuant to an authorization are exempt from HIPAA's minimum necessary standard, as long as the parties comply with the terms of the authorization, it's really never a good idea to share more information than what is reasonably required. So it's always good to have the minimum necessary standard in mind. And now that we've covered a majority of HIPAA's privacy rule, I want to turn your attention to two new changes to the privacy rules. One related to disclosures of protected health information related to reproductive services, and one related to disclosures of substance abuse disorder treatment information. The intent of the reproductive healthcare rule is to ensure that individuals will not forego necessary care out of fear that their health information will be used against them. And this rule is really a direct result of the Supreme Court's decision overturning Roe v. Wade, granting states the right to regulate abortive healthcare procedures. Because this type of PHI is extremely sensitive, heightened protections are deemed necessary to encourage information sharing amongst healthcare providers in the treatment of individuals and for purposes of documenting medical records so proper care can be given to individuals. I think it's important to know that the definition of reproductive care under this rule, though, is not limited to abortive procedures. It's purposefully broad and designed to encompass care of an individual in matters related to the reproductive system and its function and processes. So it pulls in all reproductive health care. The rules implement protections against disclosing information to a third party when procedures are performed in a state where those procedures are lawful. These changes don't grant protections to individuals in states where procedures are unlawful. The rule also requires updates to a plan's HIPAA notice of privacy practices, and it extends civil and criminal penalties for the violation of these new healthcare rights, in addition to requiring a new attestation that is required prior to disclosing any protected health information related to reproductive health care. Next slide. These new rules take effect December 23rd of 2024. And while the rules will largely impact healthcare providers as covered entities rather than group health plans as covered entities, it is important for group health plans to understand the rules and know that they're required to also make some specific updates to their policies and procedures to include the attestation process, update their business associate agreements to confirm compliance with these rules by any contracted parties, and to train their staff on these new rules. In addition to updates to the privacy and security policies and procedures, there are required updates to the notice of privacy practices as well. And though we have a little bit more time to comply with the notice of privacy practices updates, that new rule will take effect February 16th of 2026 to update and distribute a new notice of privacy practices. Now let's take a look at the attestation requirement specifically. It is strongly encouraged that plans use the HHS model notice of attestation because it contains all of the required elements. The major feature of the attestation is the section in the middle of the attestation containing two checkboxes to indicate the purpose of the request for an individual participant's reproductive PHI. The first box indicates that and is for use in states where abortive procedures are lawful, and indicates that the use of the protected health information or reproductive information will be used solely for treatment purposes. The second box applies to disclosures where services were performed in a state where those services were unlawful, and reproductive PHI may be used to investigate, identify, and impose liability on an individual. When a plan receives a request for reproductive PHI, it can presume that the healthcare was lawful unless the plan has actual knowledge to the contrary, or the party making the request provides information demonstrating on a substantial and factual basis that the services indeed were performed unlawfully. And the new rules also extend HIPAA's civil penalties to plan sponsors or covered entities in general for not conforming to the new attestation requirement before disclosure of reproductive PHI. Now let's look at the new confidentiality of substance use disorder rules. This rule as well will largely apply to healthcare providers. Changes were made to harmonize the rules under the confidentiality of substance use disorder patient records 2 rules with the HIPAA requirements. The rules in general, largely prohibit the use of substance use disorder benefits from being used against a patient in legal proceedings. They were designed to destigmatize substance use disorder and encourage patients to seek treatment. The rules have been changed to allow a single consent for disclosures of substance use disorder treatment for routine purposes of treatment, payment, and healthcare operations, rather than requiring a new consent every time a disclosure is made. The new rules also permit disclosure of records to public health authorities, provided that those records are de-identified, meaning all 18 factors that make something individually identifiable have been removed. And last, the new substance use disorder rules align the penalties for inappropriate disclosure of substance use disorder records to HIPAA's civil and criminal penalties. Next slide. Now that we've taken a look at the privacy rule and standards under HIPAA, it is also important for plan sponsors to recognize that they may have to comply with two sets of rules depending on the states where they operate their group health plans. The HIPAA rules do not override more stringent state law requirements in states that may have more strict privacy requirements than what the HIPAA rules require. And now we'll turn our attention to the security rule. The security rule protects electronic protected health information when it is created, received, transmitted, or maintained by a covered entity or its business associate in any form. Electronic protected health information can include electronic claims, email communication, digital x-rays, electronic medical records, and databases that house treatment history. Next slide, please. Any person or organization that stores or transmits individually identifiable health information on behalf of a covered entity or as a business associate is required to comply with HIPAA security standards in the protection of the confidentiality, integrity, and availability of electronic protected health information. To that end, plan sponsors have to take certain measures in developing HIPAA security standards under the privacy rule to protect that information. That may include, next slide please, designation of a HIPAA security officer, someone who is familiar with information technology and data security standards. It may include performing a risk assessment on your organization's electronic environment and assessing what threats against that environment exist and developing mitigation standards to protect electronic PHI. It includes training staff on your policies and procedures related to electronic health information and monitoring your environment as well. As with protected health information, the need for security of electronic PHI increases with the environment. Next slide, please. The more data that exists, the more protected health information a covered entity maintains or group health plan maintains, the more individuals within that organization who have access, and the more places that information is stored or travels, the more risk exists within the environment and the greater the need to implement appropriate safeguards. The security rule requires covered entities to implement administrative, physical, and technical safeguards to maintain the availability and integrity of electronic protected health information. And we will look at each of those standards a little more closely. First, we'll take a look at the administrative safeguards. Administrative safeguards are those policies and procedures and practices that apply to a covered entity's workforce in the protection of electronic protected health information. They're basic foundational standards an entity will take, like appointing a security officer, providing training, reporting, and auditing procedures. We'll next turn to the And we'll take a little closer look quickly at administrative requirements in another format. Again, those policies and procedures, contracts with business associates, privacy officers, training and development for your workforce, and providing complaint processes or sanctions or reporting of violations. Now we'll turn to the technical safeguard or the physical safeguards required under the security rule. Physical safeguards are those safeguards that protect electronic health information from physical threats like lost devices, natural disasters, and other unauthorized access. Common measures taken to protect information physically include computer servers in locked rooms, um, those screen shielding devices that make it so not everyone can see what's on your computer screen when they walk by, locking your workstation when you leave it, and other similar measures. Technical safeguards employ technology to protect electronic health information. Examples of technical safeguards include changing passwords frequently, wiping of hard drives when equipment is retired, and remote wiping of devices when those devices are lost or stolen. The last thing I want to touch on related to the security rule is that the security rule itself is a federally mandated floor of protection. It is not a one-size-fits-all approach to compliance with the security rule for covered entities. It gives flexibility to covered entities and in this case, employer-sponsored group health plan to take into account and consider their unique situation and compliance requirements. It simply requires that the policies and procedures maintained are comprehensive, meaning they address confidentiality, availability, and data integrity, that the rules are scalable and can be customized and implemented within organizations of all types and sizes, and that the rules really are technology neutral, giving plans great flexibility and designing and implementing programs with standards that are both reasonable and appropriate based on their individual circumstances. So some of the things a plan sponsor can consider in determining whether their security standards are reasonable or appropriate include their size, complexity and capability, the type of information and EPHI that they maintain, their technical infrastructure, and their access to or the probability and criticality of any potential risk or penetration of their electronic information systems. So with that, we have covered, that brings us to the conclusion of the security rule, and I'm going to turn things over to Dawn to take you through the HITECH Act's impact on the HIPAA rules and how it changed things.
Thank you so much, Shelly. The HIPAA HITECH Act is the Health Information Technology for Economic and Clinical Health Act. It is a significant part of the American Recovery and Reinvestment Act of 2009. Ultimately, it was designed to promote the adoption and meaningful use of health information technology, particularly electronic health records or EHRs. Some key points about the HITECH Act are enforcement and penalties, business associates, breach notification, expanded patient rights, those EHRs we just mentioned, as well as marketing and fundraising. So now that we have a good idea of, the key points, let's dive just a little bit deeper into some of these points. A business associate is any person or entity that performs activities involving the use of or disclosure of protected health information or PHI on behalf of or provides services to a covered entity. They will include tasks such as data analysis, processing, or even administration. The HITECH Act made business associates directly liable for compliance with certain HIPAA requirements, including the security rule and certain provisions of the privacy rule. Now, some examples that we have mentioned today of business associates will include most vendors or consultants related to the health plan. So think TPAs, COBRA, or any consumer product administrator, and even your brokers or accountants. Most business associate contracts or agreements are referred to as business associate agreements or BAAs. These help ensure business associates comply with HIPAA regulations when handling protected health information. The agreements should ensure that they define the permissible use and disclosures by specifying how the business associate can use and disclose PHI, ensuring it also aligns with HIPAA requirements. This is going to help safeguard PHI by mandating that business associates implement appropriate safeguards to protect the privacy and security of PHI. The BAA also requires the business associate to report any breaches of unsecured PHI to the covered entity. Finally, they should ensure business associates comply with the HIPAA security rule and certain provisions of the privacy rule, while also confirming they are entering into similar agreements with any subcontractors that handle PHI on their behalf. As you can see, these are crucial agreements for maintaining the integrity and confidentiality of PHI while ensuring that all parties involved in handling the sensitive information are held accountable and to the same standards. Now, business associates have several legal obligations under HIPAA's privacy and security rules to ensure the protection of PHI. Some of those key responsibilities include implementing the appropriate safeguards that Shelly told us about, regarding administrative, physical, and technical safeguards to protect the confidentiality, integrity, and availability of PHI. They are required to use and disclose PHI only as permitted by their business associate agreement and HIPAA regulations. In the event of a breach of unsecured PHI, business associates must notify the covered entity without unreasonable delay and no later than 60 days after the discovery of the breach. Business associates must ensure that any subcontractors they engage who will have access to PHI also comply with these requirements by entering into a BAA with them. They must maintain documentation of their HIPAA compliance efforts, including policies and procedures, and make those available to the Department of Health and Human Services upon request. It is extremely important that business associates should provide training to their workforce on HIPAA requirements and their importance of protecting this PHI. Now, these obligations are designed to ensure PHI is handled securely and that any breaches or misuse are promptly addressed. A quick reference or a quick response checklist for cybersecurity incidences is essential for ensuring a swift and effective response to security breaches. A quick response checklist could be broken down into 4 different parts. We would begin with preparation, where you identify key contacts, list all key personnel involved in the incident response. This includes IT, legal, HR, and maybe pieces of your management team. Then you want to develop a communication plan. Establish protocols for internal and external communication during an incident. And inventory your resources. Ensure all necessary tools and resources, such as forensic tools and incident response providers, are ready and accessible to the teams. Next, you would move maybe to a detection and analysis. Identify and confirm the incident. Use those monitoring tools to detect potential incidences and verify their legitimacy. Then you assess the impact, determine the scope and impact of the incident on systems and the data. Once you have identified, you can move to containment or eradication and even recovery. You want to contain the incident to ensure that you have implemented measures that are going to limit the spread of the incident, such as isolating any affected systems. You want to remove the malicious elements from the environment and recover the system so that you're restoring the affected systems and data from backups and make sure they are secure before bringing them back online. Once you have recovered, you would move into a post-incident activity. You want to conduct a post-incident review, analyze the incident, identify what went wrong and what can be improved. From that, you can update your policies and procedures, revise those policies and incident response plans based on any lessons learned. Now, this is not a 100% checklist. These are just ideas of what your checklist might look like. The HHS Office for Civil Rights also has an option for you to utilize for a quick response checklist. Under the HITECH Act, a data breach is defined as the unauthorized acquisition, access, use, or disclosure of protected health information that compromises the security or privacy of the information. So when we're talking unsecured PHI, this means the breach involves PHI that is not secured through technologies or methodologies approved by the Department of Health and Human Services, such as encryption or even destruction. Now, a breach of risk assessment. Organizations must conduct a risk assessment to determine the probability that the PHI has been compromised. This assessment considers factors like the nature and extent of the PHI involved, the unauthorized person who used the PHI or to whom the disclosure was made, and whether the PHI was actually acquired or even viewed. A breach discovery refers to the moment when a covered entity or business associate becomes aware or should reasonably have been aware of a breach of unsecured protected health information. Now, this is an extremely critical point because it triggers the timeline for breach notification obligations under the HITECH Act. So let's talk about a couple of key aspects of a breach discovery. Awareness. A breach is considered discovered on the first day it is known or by exercising reasonable diligence should have been known to the covered entity or business associate. Reasonable diligence, this is going to imply that the entity must have procedures in place to detect breaches and must actively monitor for those potential breaches. So now that we have discovered our breach, now we have to assess the data breach. Assessing a data breach involves several critical steps to determine the impact and necessary response. You would be looking at identifying the type of data that's involved, determine the scope and extent, analyze the cause and circumstances. Was it a hacker? Was it an inside threat? What are the vulnerabilities that were exploited? And evaluate the potential harm before you implement any remedial actions or document findings. And then again, you're going to review and update those security measures. Security breach notification laws require organizations to inform affected individuals and relevant authorities when a data breach involving personal information occurs. The notification should include information regarding the breach, explaining the circumstances of the breach, the date of the breach, the date of discovery, as well as the type of PHI involved. Employers should explain steps individuals may take to protect their information, as well as the steps the employer is taking to mitigate harm while preventing future breaches. This notice must be provided without unreasonable delay, but no later than 60 days from discovery. When a security breach occurs, organizations must follow specific steps to report and publish those notifications. Now, these requirements will differ depending on the entity size. When we're looking at an entity that has 500 or more individuals, they're going to have to submit a report to the Secretary of HHS immediately. While an entity that has less than 500 individuals, they're just going to maintain a log of such breaches and then annually submit to HHS. Sometimes in a larger employer, they also have media outlets where they're going to have to alert the local media if those affected reside inside of that same area. There have been several large breaches that have made headlines recently. The 21st Century Oncology agreed to pay $2.3 million due to 2.2 million patient records accessed by a hacker. They failed to conduct risk assessment, implement security measures. They didn't implement procedures to regularly review the system, activity, as well as disclosed PHI to third parties without any sort of a BAA being on file. Essentially, in the situation, if it could have gone wrong, it did. Then we had the New York Presbyterian Hospital and Columbia University had a combined settlement of 4.8 million to reach the largest payment in history. Roughly 6,800 patients ended up online and fully Googleable for anyone to find. These are all ways we want to make sure employers know these are real incidences that happen every single day. Now, some key takeaways from today, we want to make sure you understand whether your plan has access to PHI, where it's applicable, make sure you have policies and procedures in place, naming those privacy and security officers. We want to recognize that HIPAA compliance requires an ongoing commitment from any plan sponsor or entity. We also want to make sure you have those covered entities and business associates and have established their own internal policies and procedures to address new breach notification rules, deadlines, and possible exceptions to any rules, as well as ongoing employee training. Ultimately, we hope today was very useful to you. If you have any questions, please do not hesitate to reach out to your hub team. We greatly appreciate you joining us today.